Thanks for joining me today. I'm attorney Justin Randall with Hooper Law Office, and today we're going to be talking, very timely, of course, as our webinars always try to be, but about planning for up north property or family legacy property. So what we mean by that, because these might not actually be geographically up north, but these types of properties are things like cottages, hunting land, lake homes, properties that the family hold dear to themselves and want to plan for to pass on to the next generation. So we're going to be talking about not just how to plan for those and pass those on, but also how to make sure that we are planning to protect those from certain concerns as well. So before I go too far into that, just know that you can submit questions through the Q&A function of Zoom, and I'll be able to see those come up. But another thing is at the end of this webinar, you'll receive a couple different things from us. You'll receive our feedback form, which lets you know, or lets you give feedback, of course, and lets you let us know that you would like us to reach out to you to set up time, come in and talk to one of our attorneys for our initial consultation. Those are complimentary. We do schedule them for about 2 hours to give us enough time to go through everything. But if we talk about something today that makes you think, oh, I really need to talk to somebody about this, about my family property or about estate planning in general, feel free to fill that out and that'll let us know to reach out to you. And then on top of that, you'll also receive our planning for up north properties tool. Which is just a handout we have for you it can be really helpful to kind of summarize the points we're going to make today. So, all right, so getting started on that, as I sort of mentioned already, when we're talking about up north property, which, the kind of joke in Wisconsin, or I guess in the Midwest in general, is up north is just wherever you have this property. It could be down south, it could be east, west, actually north, but up north property is what we tend to lovingly refer to as cottages, family homes, property that's important to the family, but is not the primary residence of those family members. Although I suppose it could have been at one point, but it no longer is too. So this could be hunting land as well. There doesn't have to be a building on the property either. So these properties are incredibly important to plan for because so often, the point of these properties is, passing on to the next generation is to keep that family together, keep, that tie that binds the family even after you or your loved ones have passed. But the problem so often is that when there's not enough planning done, or the planning is not done well, or, certain things are not taken into account, sometimes these properties can end up being very divisive in the long run, right? Because ownership with a lot of different people can be very hard. It's, how do you deal with disputes? How do you deal with bill paying, things like that? And so often these properties are passed from maybe mom and dad, or mom and dad and, dad's siblings, however it was owned initially. And you usually anyway have more owners at the subsequent generations, each generation, because each person then is passing on that interest. And that would be, for example, somebody who really doesn't have any specific planning in place for it, or has maybe not planned for it in a way that will help deal with those issues, that each person is allowed to pass it on to whomever they want, and therefore it ends up kind of the number of owners tends to explode over time. There's very real stories out there of people who have these sorts of properties where generations down the line, there's almost annual business meetings for these sorts of properties because they all have equal say, voting rights, and they all have the ability to make decisions on certain things. But now there's 50 owners of the property, and they all have to come to this agreement. Otherwise, nothing will ever get done. I know specifically of one story where the family almost has essentially a family convention where they meet to deal with things like, how do we pay for property taxes? How do we deal with this repair, or deal with any sort of environmental regulations that are now being put on the property that we didn't have or know about before. And unfortunately, a lot of times those properties end up then sort of falling into disrepair because there's just no efficient way to deal with it, right? So when we're talking about planning, there's things we can do to protect the property from certain liabilities as well. But really, the thing that is going to be absolutely paramount to making sure that this is successful is making sure there's a structure in place for the next generation of owners to actually make certain decisions and how to deal with disputes when they arise. I don't mean if they arise, I mean when they arise, because inevitably, depending on the number of owners you have, people have disagreements all the time anyway, but the more people you have involved, the more you're increasing that chance that there will be a dispute at some point. I've had plenty of my clients come in where they inherited a property from mom or dad, and now they own it with their siblings or their siblings and an in-law. And, the relationship is beyond repair because they just do not get along. They're not willing to, get along anymore or sit down and actually try to work things out. So there's really a couple key things that you want to make sure of in terms of decision making for the next generation, or rules for the next generation that you want to specifically lay out somehow for them. And there's a couple of ways to lay that out. So first, how does bill paying work? Property taxes are always going to be a continuous thing that you're going to have to pay every year, right? How does that work? Is it does everybody have to pay their fair share? Does everyone take turns paying the property taxes? What are the guidelines for that? And what specifically would happen should somebody not fulfill their end of that obligation? And what if somebody just is refusing to pay property taxes? Does that impact their ownership? Does that impact their right to use the property? These are important things to think about. Usage of the property, speaking of, are there any rules or like calendars of usage? I mean, again, when you start to get more and more owners involved in the property, if you have 50 owners, it's going to be very difficult for everyone to use that property when they want to, right? And it might lead to tension where somebody's using it more than their fair, allocated time would be according to the number of owners. So are there meetings that have to take place every year between the owners of that property where they sort of calendar out, this is your weekend, that's my weekend. And if somebody starts to violate those usage rules, what happens, right? One very common concern is the amount of the expenses and repairs and maintenance that somebody has to pay, is it based off of how much they're actually using the property? Is there almost like a rental fee for the family where, all right, if you're using it this number of weekends, you pay that percentage of the property taxes, right? Or whatever the expense might be. So these are things that most people don't think about or just don't think are ever going to be a problem. I hear a lot of, well, they get along, so it won't be an issue. And that's not the type of planning I would want to put in place, because that could potentially be true, but generally speaking, it's not, and I'm not willing to stake my reputation on that. That's for sure. So usage, bill paying, all very important. But what also is incredibly important is you've passed this property on. Well, what happens when one of them, the next generation, passes away? Who are they allowed to leave that property to? Can they leave it to anybody they want? A spouse, a friend? Their kids? How does that have to work? Or is the goal to keep it in your family? And do you then have requirements that that person cannot pass it on to anybody that is not a direct, descendant of yours? And you can, of course, define immediate family in a number of ways too. But very commonly, we'll have some sort of restriction on transfers of the ownership by saying that this person, or any owner of this entity or property cannot pass it to anybody who is not a direct lineal descendant of, Bob and Jane Smith or whatever. And so that's really important, because you can do this planning and put sort of these rules in place. It is much, much harder if this planning is not done initially and it's already made it down to the next generation, or maybe a couple generations down, to figure out, how do we come to this sort of agreement? Because the more owners you have involved, not just with bill paying and things like that, but in putting these restrictions in place, the more people you have involved, the more likely it is they're not going to be on the same page. And if these rules are not already in place, if all it takes is one or two people to not agree with those rules that everyone else wants to put in place for that to be an issue. So how do we put these rules in place? Might be a question that you have, and rightfully so. There's a couple different ways to do this, but what you would not want to see done is just have outright ownership go to the next generation, right? You don't want to have it be, my wife and I own this lake home and all of our 5 kids get ownership of that property through just by a transfer of deed or through probate or however it's transferred after I pass away. The reason that's not a good idea is because now that they just own it outright, there's no rules in place, right? I mean, there's laws in place, of course, but in terms of amongst the various owners, there's no real rules in place of usage or bill paying or dispute resolution, right? So a very common tool that people will use is some sort of essentially a business entity to pass this on. Very commonly, LLCs are used for this purpose, right? Cabin LLCs are a very common tool. And LLCs then have what's called an operating agreement, or at least should have what's called an operating agreement. And actually under a law that passed this past year and will be in effect starting next year, you have operating agreements if you have text messages amongst all the family members and you've come up with rules, or you have operating agreements if you've written letters or emails. I mean, so most LLCs will have an operating agreement whether they know it or not, just because of the new rules coming into effect. But what you want to have is a written operating agreement where you set this up before it passes on to the next generation, ideally, where you lay out the ground rules in a written document that you and the other current owners have agreed to, saying what happens in terms of bill paying, or if somebody doesn't pay their fair share, or who gets to make certain decisions on things, or are there kind of elected officials for the family that make certain executive decisions that based off of bill paying or certain tax filings or whatever it might be. And also specifically references who those owners of that LLC can pass their interest to. And that's really where you can put that defining restriction in place, saying, that it has to be an immediate family member of mine or a direct descendant of mine, and cannot be a spouse. It cannot be some family friend or whomever. Now, with operating agreements for LLCs, the rule book, so to speak, those can always be amended by the members, but you can set the threshold that's required for certain things, right? Do certain decisions have to take a supermajority, or can it just be a simple majority making this executive decision? When it comes to amending the operating agreement, it takes all of those members to sign off on that. So assuming the next generation actually is on the same page for something, they can always change those rules too. But it's much harder for them to change the rules you've already put in place, because again, you've got more people involved in that than it is for you to put them in place to begin with. The opposite is, of course, also true, where it's so much harder for them to institute new rules on themselves because of all those different people than it would be for you or you and your spouse to do so, because it's just you or you and your spouse making that decision. So LLCs are a very common tool for this, planning for these sorts of things, but so are certain types of trusts can be used for like cabin cottage trust, where somebody is putting this in place. All the family members are the beneficiaries of that trust, or the people that you want to be the beneficiaries of that trust you've named. And it lays out the ground rules for what happens if somebody isn't paying their fair share, sort of like an LLC, or what happens if somebody just wants out? Do they have a right to any sort of payout from that, or do they just sort of forfeit their share, right? So I tend to prefer using LLCs for that, because I think it provides a little bit more flexibility in the long run, and also provides some liability protection on top of that for the members. Trusts can do that as well, but when it comes to cottages and like management decisions, it can potentially be a lot easier to use an LLC than for the family to continue to use a trust that goes on for generations and generations. Although trusts are phenomenal tools in their own right, but just for different reasons. So one of the things outside of just making sure this transition is smooth is making sure that your family property is actually protected from certain things that you might be concerned about losing it to, right? A very common concern that we have for current owners of properties, or the owners themselves have when they come in and talk to us, is what happens if I go into a nursing home? What happens if I need long-term care? What happens to this family property that maybe has been in the family for generations, or even if not, is very important and we want to protect for the next generation. So, your primary residence that you have, as long as one of the spouses is still healthy, living, at home, all of that is unavailable for the person who's in care for their care. However, subsequent pieces of real estate, additional plots of land, properties, whatever, those are counted as an asset for that person's care. So what that can mean is potentially the family may have to sell that property to pay for mom or dad's care, or both. So how do you protect that? How do you, get that off of the table? Well, One thing I would not recommend doing is gifting it directly to the next generation. And there's a couple big reasons for that. One, as I've mentioned already with the LLCs and the operating agreements, the rules you can put in place, by just gifting it to the next generation, you don't have those rules in place. But on top of that, it can be just as much of a risk to give it to that next generation as it is for you to keep it for your own care. When you give it to more owners than maybe owned it initially, now you don't just have your liabilities to worry about, you also have all of the next generation's liabilities to worry about too. Whatever happens to the owner of a property happens to the property itself as well. So if you went from 2 owners, or maybe because you're a married couple, just considered legally 1 owner of that, did you go to 4 owners, 5 owners? What's the number of people we now have to worry about? And what happens if any of those people get sued or gets divorced or files for bankruptcy, right? What if they need long-term care? You don't want to protect it from your care just to open it up to a bunch of other liabilities that you couldn't have predicted. With Medicaid in particular, they have the 5-year look back. So a lot of times people will try to make these transfers well in advance of ever needing care. But what if you've made it well beyond those 5 years, but then another liability for one of the owners comes up? That can be a really big risk. It's also not really good tax planning. When you bought the property or when you inherited the property, the value of it at that time, what you put into it, that's your cost basis. And that's how the IRS would determine any taxable gain, the difference between that cost basis and what it was sold for. So it could be a loss too. But generally it's a gain. But when you gift property over to somebody and they don't purchase it from you or they don't inherit it, they get that same cost basis that you already had in it at the time of that transfer. So that means if they need to sell it at any point, or they're making depreciation deductions on something over time, then they have much less of a cost basis to work with, and they may have more tax consequences because of it, a higher tax to be paid. Now, I know a lot of these plannings or the planning with these properties is meant to keep it in the family for generations upon generations, but you don't want to have somebody only have to hold on to it because it would be a huge tax liability to sell it. There could be plenty of reasons that the family no longer wants to hold on to the property and they all decide to sell it too. So you don't want to, artificially hamstring them in any way just because of, your goal is to keep it in the family long term. If that's not what they decide they want either. So, tax planning, it's not great, but part of it too is could be a huge loss of control for you. While you're still living, do you like still using that property? And what happens if there's a falling out with any of the family members, or you don't want all those family members to be using the property when you would otherwise want to be using it, right? How does that work if you've given all of that ownership interest over already? So there's better ways to deal with this. And one of the ways we tend to deal with this is through what's called an irrevocable trust, where you're still dealing with the 5-year rules for Medicaid look back and all of that. But the trustees of that trust, who cannot generally be you, might be the kids or one or more of the kids. They can't stop you from using the property as long as you are paying the property taxes, utility bills. They don't necessarily have a right to use it. They can't sell it without your permission. They can't, you still get to kind of dictate the rules on that in terms of usage. So it's much safer for you to have it in an irrevocable trust in terms of your own usage and protection than it is to give it to somebody else. On top of that, though, that irrevocable trust still gets a step up in basis when you pass away. So it would, the way we would draft it anyway, so that you can avoid that capital gains issue for the next generation if they do end up selling it. And for, the biggest thing I think anyway is by having your kids on as trustees, that does not give them ownership yet. So what that really means is that their individual liabilities that might be going on outside of the trust, for themselves, has no bearing on the trust assets. They don't own it yet. They are managing it as trustees, but they do not have ownership. So if one of the trustees gets sued, files for bankruptcy, or gets divorced, that cottage or family property is not subject to that liability because they don't own it, right? So it's much safer to do that. And we often use this type of trust-based planning, irrevocable trust, as well as cottage or cabin LLCs in conjunction with one another. And the reason you would do that is because your LLC does not necessarily protect you from the assets within it. from long-term care expenses, which is a really common misconception. It has to be an active trade or business for it to not be a countable asset. It is not an active trade or business simply because it is an LLC. And so often with these types of LLCs, you're really just using it for liability protection. So, something happens on the property, you as an individual are protected, and as a way to set up the rules for the next generation. But that's not an active business. It doesn't even matter if you're renting it out a couple weekends of the year. Rental businesses, in order for that to be an active trade or business, you have to be substantially involved in that industry. You have to be engaging in 20 plus hours a week and going to certain conventions, and essentially your business has to be that you are a landlord, not like we rent it out on Airbnb every so often. So LLCs by themselves do not protect those assets from long-term care necessarily. And it's even with that business exemption, it's not something you want to rely on long-term, because it is still available for Medicaid to come back later with a state recovery too, against your interest in it. So what you would want to do is, if you want to set up those rules for the next generation, you want the LLC there for liability protection for you and the kids going forward, the liability of that property, but you also want to put the rules in place for usage, for how they're going to manage certain, disputes if somebody wants to sell their interest or doesn't want to be involved anymore. That's that part of it. But then you can then put your LLC interest into that irrevocable trust and then get the protection from your long-term care as well. So we do very commonly use these two things together. And I won't try to bore you too much on the specific, inner workings of an irrevocable trust. And also, just because I could be here all day if I'm doing that, I'd be more than happy to talk that long on it. But I'm sure you have other things you want to do too. So, protecting this property is very important for a lot of people. But I think, and one thing I'll sort of close out with here is, it's also really important to just be realistic about the future of that property. I think very commonly we see this a lot, for example, with farm families sometimes, but also with hunting land or lake homes, anything like that, where the parents really want it to be that binding family property. They really like the idea of the family kind of having this point to go back to, or something keeping them together, but they've never really talked with any of the kids, or they haven't talked with all of them, or really gone into a lot of detail about how this would work. So they have no real idea if the next generation actually just wants to sell it anyway. Maybe they have no interest in it. Because I do this for a living, and this is always on the forefront of my mind. My brother and I, he and I were joking that if mom and dad ever bought a property in Michigan, where my family lives, that I told him he could have it because I don't want to deal with the fallout, or potential disputes, and I love him too much to have that happen. And he jokingly said, well, I'd probably just sell it anyway. So that conversation we jokingly had, my parents were right in the room and heard that. So those conversations, maybe in jest, but in all seriousness as well, are very important to have, because if the next generation has no interest in actually keeping it, what are you doing all of this intricate LLC planning for to begin with? You might have it for your own liability protection, but do you really need to go super into detail about, here's the dispute resolution provisions for this next generation, here's the transfer restrictions, things of that nature? Is that really important to go into great detail on it? And maybe it is, but maybe you want to do it anyway because you don't know that they're actually going to sell it. I mean, you can plan for those sorts of contingencies as well, of course, but you don't need to go overboard with things either. If it's just all the kids just decide, yeah, we're not going to keep it, we're going to sell it right away. So why are you, putting any sort of restrictions on it? And in particular, don't do something like nobody can get any value for selling it. If don't put any rules like that in place if everybody just wants to sell it anyway, because one, that wouldn't really work, but two, now it's just not the right planning for what the reality is. So sit down and talk with them, have the discussions, and sometimes too, maybe that one child has no interest in being involved, and maybe you want to allocate more of your estate from a different type of asset to them to make up for that. Maybe that's not an option, and you talk with that person who doesn't want interest in the property or doesn't want to actually maintain it after you're gone, and they're fine with the fact that, well, because I don't have to deal with the expenses and things like that, whatever, I'll take less of the rest of the estate, and they can, because that's more important that you give it to the people who want it. I'm not saying everybody's going to have that opinion, of course, but it's always a possibility, but you don't know until you have these discussions. There are plenty of families where some people are interested in the property and some aren't. And that's not going to get any clearer or easier after you pass away if you don't have that plan for it to begin with. Because now if somebody doesn't want to be involved in the property and they really do just want out, but the other owners don't want to sell the property or are not able to buy them out, and there's no other rules in place for what happens if that dispute comes up, that's where the driving wedge can come in between family members. And now your plan to keep the family together with this property is no longer really effective. It's kind of done the exact opposite, in fact. So the practical side of things, talk with everybody first. Once you know what the plan is or what people's interests are, and you might have to tell some family members who are kind of on the fence and say, I really need you to make a decision one way or the other. I can't have you on the fence with this, and give them the ultimatum on it potentially, and just say that, you have to actually make a decision on this. But once you know that going forward, then you want to look at, okay, what do we need to put in place to make that happen? How do we make sure that that's as smooth as possible? Involving LLCs, involving trusts, right? How do we make that work for them? And how do we accommodate people who don't want to be involved in it? Are we able to allocate more of other assets over to them, or is really the only asset we're going to have left this property? Is that something that, they might not receive it then? And that's something that you're going to want to have that conversation with everybody. But once you know that, that's when you can get the planning in place. And then once that planning is in place, hopefully it's where the next generation has the guidelines that they need for when those disputes arise and when they have to do the planning of their own. But the worst thing you can do is doing nothing, or just, avoiding the conversation because it's a difficult one to have. That's true of any really area of estate planning. And a very common thing that occurs is where people avoid the discussion entirely because they don't want to know the answer to it. And I suppose that's common in life as well. But it's very important, if your goal is to keep this in the family and keep it binding the family together, that you do proper planning. And on top of the rules for the next generation, like I've mentioned, if you have concerns over your own long-term care expenses eating away at assets, you have a couple options. I mentioned the irrevocable trust as one. If you have long-term care insurance that is able to cover the cost of your care, or can substantially cover the cost of your care, maybe you don't end up needing that irrevocable trust. Sometimes we use both in conjunction. So there's a lot of factors involved in protecting it for yourself, but that's the easy part. The hard part can be figuring out how it's going to work for the next generation. And that's just because now it's not just you making those decisions. It's not just you that you're worried about in terms of what wants and needs, right? It's a bunch of other people too, potentially. With that, I don't see any questions, but I am running low on time here. Just a reminder that next week, our webinar is actually on understanding Medicaid eligibility. So I've touched on that a little bit today. I'll go in a lot more detail about it next week. So same time, and keep an eye out for those feedback forms where you can sign up for initial consultations. And again, those are complimentary, and we schedule them for about 2 hours. If you have any feedback, we'd love to hear it, but we'll also be giving you that handout on planning for up north and cabin and, hunting land properties and all of that. So with that, I will let you guys go enjoy the nice sunny day outside, hopefully where you are as well. And thanks for joining me.